that you are holding that has words or pictures on it was basically produced by the two of them, so I want to give them a special thank you. I also want to thank our moderator for the first part of the day, Kamal, and also the morning presenters. And I'm going to turn it over to Matilda Roman. She's our afternoon moderator. She is a graduate of New York Law School and is the Deputy Commissioner and General Counsel to the New York City Mayor's Office of Immigrant Affairs, MOIA, where she advises executive staff within the Mayor's Office and other key government officials on policy directives and initiatives affecting immigrants residing in the city of New York. She also teaches immigration law and policy for the City University of New York. Woohoo! CUNY. I can't miss a chance to plug CUNY. Prior to her appointment, Ms. Roman was also the Director of Immigrant Initiatives at the New York City Department of Youth and Community Development, where she oversaw contracts given to over 80 community-based organizations that provide immigrant-related programs and services to the city's newest New Yorkers. So please join me in welcoming Matilda Roman.
Good afternoon, everyone. Has everybody been fed? Refreshed? Energized for this afternoon session? So, a few housekeeping items before we continue with the afternoon panel presentations. Reminder for the folks in the audience, if you have questions for the presenters during the Q&A session, please write them down on the index cards you were given and pass them to your left for our staff to collect. You will have a chance to ask questions about the entire training at the end of the presentations. For folks watching at home, you can send us your questions using the chat box on the right side of your screen. And all viewers here and at home can send their questions via our Facebook page or via Twitter using hashtag CNTraining. Reminder, be sure the light on the clicker, the eye clicker, is on so that your answers can be counted during the audience poll. And please do not leave today without returning your eye clicker back to us. Staff members will be stationed at the door to collect the eye clickers, and we will track you down if you take it home. So that said, I want to introduce our first presenter for the afternoon, who really needs no introduction. It is Alan Warnick, who is the professor at Baruch College, City University of New York, and the director of CUNY Citizenship Now. Woohoo! His column, Immigration Law, appears twice weekly in the New York Daily News. His weekly column, Immigration and Citizenship, is syndicated by King Features Syndicate. Professor Warnick has taught immigration and policy at the University of California, Los Angeles, and at California State University. Professor Warnick has served on the National Board of Directors of the American Immigration Lawyers Association, AILA, as chair of the Immigration Committee of the Association of the Bar of the City of New York, and as president of the New York chapter of the American Immigration Lawyers Association. Please give a warm round of applause for Mr. Warnick.
So are we learning something? All right. Uh-oh, where did I go? Wait. Okay, hot topic. So, by the way, I want you all to practice. Could you all raise your hand? Just raise your hand. I want to make sure you can all raise your hand, because that's what you're going to do when you don't know the answer to a question when somebody calls, okay? So, what I'm going to try to do is to help us answer questions that we might get from callers about some of the recent and proposed changes in our immigration laws. And we're going to start with prosecutorial discretion. And what prosecutorial discretion means in general, it means that the government has the authority to let you go, to leave you be. And in the immigration context, it comes up when a person is deportable or removable, that is, the government could make them go home, but they decide not to. And as one of the few pro-immigrant things that President Obama's administration has done, this is one of them. He's instituted a program to make a priority of certain cases for removal and to let some other people stay here. So there's a few things we need to know about it. First of all, the primary benefits are people with pending and newly filed cases. So that means if a person has not been ordered deported, they have a much better chance of getting prosecutorial discretion. That is, that their case will be closed, administratively closed, so that they don't have to worry about being deported. By the way, they do not get employment authorization, but they're just allowed to stay here in a status which they're not going to be deported if they don't do anything bad, but they're not also on any path to legal status. So this is not an amnesty in that sense. People with outstanding deportation orders, that is people who have already been deported, I said does not include, as a general rule, that's true. If you have a particularly sympathetic case, like a victim of domestic violence, somebody who has lots of children here, you may be able to get the government to allow that person to have a stay of deportation. Reopening is much easier. So if, let's say a person had an order of deportation, but now they're married to a U.S. citizen, or they have a child who's over 21 who's a U.S. citizen and they entered legally. It used to be a big struggle, but under the prosecutorial discretion guidelines, the government has been much more lenient. That doesn't mean it's easy and it's going to be in every case, but they've been much more lenient. And it's always best in these kinds of cases that you get legal assistance. A couple other points one other point I want to make about it is that one of the reasons you need legal assistance is because it's not always a good idea to get your deportation case canceled, because there might be some benefit available to you. For instance, if a person's been here 10 years and can show extraordinary hardship to their to certain permanent resident or U.S. citizen relatives, or if they're trying to pursue an adjustment of status application, as Jojo Annabelle explained this morning, it can be renewed in a deportation, or they're applying for asylum. So not everybody wants to get out of deportation proceedings, right? Some people want to stay in it. The factors that they consider are your immigration history, family ties. They've been especially lenient with DREAM Act students, and whether eventually the person's going to get some immigration relief. Now, there's nothing to be gained by turning yourself in to get prosecutorial discretion. That's not how this works. There's no benefit to doing that since you do not get employment authorization. The reason a person wants to get prosecutorial discretion is because they're already been put in removal proceedings and they want the government to leave them alone. My guess is that many of the calls that we're going to get are people with criminal records who've been ordered deported, who've absconded, or who the government has not tried to deport, and they're going to want to know if they benefit. And the answer should be, as a general rule, probably not, but it cannot hurt for them to speak to somebody in particular about their case. This is not for criminals. If you think about the genesis of it this is why I always, when I study for the bar, I try to think, why is the rule there? Not to memorize the rule. And the reason the rule there is to get Obama reelected. And that means that he's not going to want to let criminals stay here, okay? That's pretty direct, right? Okay, now, another effort by the Obama administration to get the president reelected without providing any genuine relief for undocumented immigrants. I know that's very cynical of me, but you know, that's what happens with age, is the unlawful presence waiver rule. Now, some charlatans have been promoting this as an amnesty. It is not an amnesty. What this rule applies to is for people who cannot adjust status, which you learned about in very good detail. I thought excellent presentations this morning. Let's say the person has to go home for their immigrant visa process, and we call that consular processing. But if they've been here more than 180 days, they can't come back for 3 years, and if it's 365 days or more, they can't come back for 10 years unless they can show extreme hardship to a parent or spouse. Notice not to a child, right? To a parent or spouse. They need to get a waiver. Where under current procedures, in order to get the waiver, you must travel home, apply for your visa, and then apply for the waiver. So if they say no to the waiver, you're stuck for 10 years. That's not good. Nobody wants to do that. Even though the approval rate is very high on these waivers abroad, people don't want to take the risk. You know, do you really want to risk leaving your wife and children to go to Mexico or to Haiti or to the Dominican Republic or to Jamaica to apply for a visa knowing that you might be stuck for 10 years? Well, the answer is no. A lot of people have been waiting here for years. Well, under the proposed rule, the person will be able to apply for the waiver here. If they get the waiver, then when they go home, it's not an issue, right? They go home, it's a routine interview. And before the unlawful presence rule came about in 1996, who was president then? No, 1996, our friend Bill Clinton, our liberal, progressive, pro-immigrant Bill Clinton passed the most restrictive immigration bill in 50 years, but don't tell him I said that. Before that, I used to practice law many years ago, we would routinely send people to interviews abroad, and they would come back with their green cards. And if this rule works the way it should work, that's what will happen. The person will have been here more than 180 days unlawfully. They will be married to a U.S. citizen, let's say, as one example. They'll file for the waiver. Immigration will approve the waiver, and now they'll go for routine consular processing. There's a few things to note about this. First of all, it's not a rule yet, so you can't apply for it yet. You can't submit your waiver. Now, what I recommend is that people start gathering their materials to show hardship to their spouse or parent. Make sure they file their income taxes. Make sure they have other records of their presence here. If their family members have medical problems, they should keep a record of that. But eventually, we think in the next 2 or 3 months, it will be a rule. The next thing, it only applies to immediate relatives of United States citizens. That's the unmarried children under 21, the spouse, and the parent of a 21-year-old U.S. citizen. So that means that if you're the brother or sister of a U.S. citizen, this rule doesn't apply. Yes, you can go home. Yes, you can apply for the waiver at home if you have a spouse, or let's say you have a spouse who's a permanent resident, and you qualify for a waiver by showing extreme hardship to your spouse. Well, this rule is not going to help you. Now, if your spouse becomes a U.S. citizen, then this rule is going to help you. So it's only the immediate relatives of U.S. citizens. And when I'm telling people in my column and when I meet them, if they ask this question, let's just wait until the rule. Don't go home. This is not the time to go home and try and get the waiver abroad, because we know this rule is going to happen. And I'll make a prediction. And my prediction is it's going to be very liberally interpreted. That means that most people, almost everybody, if they don't have a criminal record, they're going to get the waiver. Most people are going to get the waiver. So let's just wait it out, spend a few more months here undocumented, and then you'll be able to go home. And again, the idea is, the only difference is between the current rule and the rule going forward is that you'll be able to get the waiver before you leave. And that's very, very important, as the earlier examples pointed out. And the reason that the Obama administration is able to do this is because it's a regulation. It is not a change in the statute. Meanwhile, I don't understand why this rule, why we weren't allowed to do this 10 years, in 1996, but that was how restrictive immigration was. So we have to give the Obama administration credit for, in their effort to get reelected, that they're changing this rule. Okay, the New York Dream Act. The New York Dream Act is a law, a proposed law, a bill that would grant access to state-sponsored financial aid, to scholarships to undocumented immigrants. The National Dream Act is a law that would make permanent residence or give a path to citizenship to undocumented immigrants. I don't see that happening anytime soon. You know, candidate Romney is saying that he wants one, but you have to go in the military. And potential vice presidential candidate from Florida is saying, well, we're going to give them some kind of legal status, but we're never going to let them become citizens. Neither of those things, I think, are going to fly. And until I'm suggesting that, and I tweeted that that in 2014 we may see, I believe we will see, a National Dream Act which provides permanent residence. But people start asking, will I qualify? That's a common question. Well, I'm 35, or I'm turning 35 this year, because that's one of the cutoffs. I think you just have to say, Well, we don't really know. There's no point in speculating, because there really is no point in speculating. You know, it was 30, it was 35. They could make it 36. They could make it 40. They could make it 25. In terms of the cutoff, your age at the time the bill's enacted. So there's no way of knowing until it happens. In terms of the New York State, going back to the New York State law, I just started with the New York Dream Act because that's the title here. There are two bills pending in the state legislature. One is the financial aid bill that I just mentioned that would grant access to financial aid state-sponsored scholarships to undocumented students. The other would create a fund, a state-sponsored fund that individuals and corporations would contribute to, and that state-sponsored fund would provide scholarships to undocumented students. And there's some people that feel that as politically it makes sense to push the DREAM fund first and then try and get the State DREAM Act passed, and I'll let you judge whether you think that's a good idea. But again, these are not laws, these are proposals. By the way, we have one of our visitors going to be Assembly Speaker Silver, so we'll have to talk to him about that. And you know, this is an aside. You know, my mother used to say about meeting fish, she said, oh, so-and-so met a movie star, said, but they still put you know, they don't eat or sleep any better than we do. You know, when I meet an elected official, I have to have an agenda. What's the point? I mean, what's the point of shaking hands? You know, I shook hands with President, he was running for a second term, President Clinton. He was on a stage like this. I said, let's do something for the immigrants this year, Mr. President. You got to have a pitch. So when you're at the call-in, there's some elected official comes around and shake your hand and says, we really appreciate your volunteer. Say something to them. Say we need something, whatever it is, you know. And so that's one of Wernick's rules there. Okay, voting. It's important that people understand the rules for voting, but also that as was pointed out earlier, you know, you have to be a U.S. citizen to vote. That's why when we have our weekend citizenship application events, we don't allow voter registration tables. And the reason for that is we want to make sure that nobody files a voter registration application before they become a U.S. citizen, okay? Because not only is it a crime, but they could end up being barred from future immigration benefits. But it is worth knowing, in case people ask about it, and you know, I'm not going to read this. I think it's pretty clear from the slide. But you should have this information in front of you. If people call, we are encouraging, as part of our marketing, we are encouraging people to call in and get information about voting. But you'll note, the only point I would make, you'll note on the second point, it says individuals naturalized after that day, that's October 14th, have until October 28th in which to register. So we want to encourage as many people to register as possible, and I don't have to tell you why. So I want to thank you again for all participating. I know you're all learning something because I learned something. I had to take a few notes this morning on one of the presentations. There was something I was not aware of, and I've been doing this for a long time. So my just last final points, I don't see anybody waving any flags at me to jump down, and I'm a lawyer, I have to keep talking. Okay, they're waving at me. I'll just say this last thing. You know, every single call, and this is our 10th, as you know, there's been one caller who called with something, and I had to say, let me get your phone number, I'll call you back, and I've been doing this a long time. So the fact that you don't know something is nothing to be ashamed of. Raise your hand, we'll get you help. We have literature there that can help you. Thank you so much. See you later. Oh, and don't forget we have wine and food later.
Thank you, Professor Wernick. It's hard to tell the boss man that he has no time left. Our next presenter is Tamara Blue, and she is the legal coordinator for CUNY Citizenship Now. She has been an advocate for the rights of underrepresented people since 1999 and has worked in private practice, nonprofits, and legal service agencies, providing advocacy on behalf of immigrants and people with disabilities. She is a graduate of Binghamton University at CUNY School of Law. Yay. While a student at CUNY, she represented battered immigrant women in the Immigrant and Refugee Rights Clinic. Tamara is a member of the American Immigration Lawyers Association and the New York City Bar Association, and she will be talking about call-in procedures and resources. Please welcome Tamara Blue.
again. I always have a really tough act to follow. So I'm going to be talking about the legal resources available, the people resources available, and just the day-to-day procedures for the week of the call-in. This year, we have a brand new location. We are going to be at the new community college, which is across from Bryant Park. It's a really, really cool new building. The date of the call-in is listed on the presentation, and this year we're in a much different space. It's more comfortable. We will all be in one room together answering the phones. As people remember in the past, the Spanish phone lines and English phone lines were in two different places, so now we'll be all together. I'm going to just make a quick reminder again that people should submit their bio by tomorrow. You can talk to one of our staff members for help if you don't remember receiving the email, you're not quite sure how to do it. We'd be happy to help you. The deadline is tomorrow, though, so if you want to get it into the daily news, don't forget when you leave here tonight. So the goals of the training today are really to orient everyone to the basics of immigration law and to provide you with a foundation for answering the questions that you're going to receive. We do surveys throughout the call-in. Some of the callers answer a survey while they're speaking to people, and we do this training based on the information that we get from the callers, and we tailor the training to the information that they most ask about. So that's why we started with the building block of family-based immigration, and that's why we're transitioning from family-based immigration to adjustment of status, and this afternoon is about citizenship and naturalization and acquisition and derivation, and don't worry, you'll get to use your iClicker again shortly. Someone asked me at the break if the webinars will be posted online. They will be on our YouTube channel, but we'll also post the PowerPoint because some of the presentations were very complicated, and we'll also post the webinar questions and the poll questions and the answers so that you can familiarize yourself with them, because it was a lot of information for today. We understand that. I'm sorry that we didn't have it in front of you, but it was like 400 pages. We didn't want to kill that many trees. So the goal of the call-in is to provide free information and referral on a range of immigration issues. We want to connect the people that call, because they call from all over the country and all over the world, with reliable, authorized immigration service providers, and we want to make a difference in the lives of immigrants. That's why we're all there. We also want to comply with New York State laws prohibiting non-lawyers from providing immigration advice, so we want to remember to comply by providing information. We want to make sure that we keep everything confidential, and we want it to be of the highest quality. So I'm going to also encourage people, if you have a question you're not quite sure how to answer, please raise your hand, and we'll be sure to send someone over to guide you through how to answer the question. I believe in your packet you have something called the Getting Started Guide. That sort of outlines the code of conduct, the basic rules for dealing with one another during the call-in. Once again, we ask that you don't take the names of callers, that you don't give the names of volunteers. We really want people to feel comfortable that the service is anonymous. We don't allow any private referrals to for-fee services, and we also provide a referral list, which I'll point out to you guys a little bit later. We are going to have one supervising attorney or BIA accredited representative for each 4 to 6 volunteers answering the phone, and some of you are familiar with our sashes. We'll be wearing those, and people will be walking around, and they're more than happy to answer any questions that you have. So how do we take the phone call? Number one, if you look in your Getting Started guide, you'll see that there is a disclaimer. In order to comply with New York State rules, we have to read this disclaimer each and every time we answer a phone call. It's printed in English and in Spanish, but if you speak another language with the caller, we ask that you sort of translate it for the caller on your own. It protects you It protects the caller, and we just want to remind people to read it, so we'll have it for you on the day of the call-in. Step 2 is getting the information that the caller is getting the right questions, asking the right questions so that you can give the right answer. Some questions are these questions here. What was the date that you first came to the United States? How did you enter the United States? These questions are on this orange sheet. I think the back 2 rows we may have ran out of copies, but this orange sheet is a guide to helping the caller get the information that they want. So if you have a question for a supervisor, you can go step by step through all of these questions. These are some more questions that you want to ask the callers that sort of get to the heart of the issue that they're asking about. For callers who are interested in naturalization, we have 2 gigundo resources. One is the call-in training manual, which has a section on naturalization, and the second is the Citizenship Now guide, which those of you who come to our events are very familiar with. It's step by step by step on naturalization, and according to the surveys that we receive, about 50% of callers call about wanting to become citizens. So this is a great resource to familiarize yourself with when you go home tonight. And also on this orange sheet, there's a column A and column B on the side for callers seeking citizenship information. So it gives you an idea of some of the questions you want to walk through to make sure people are eligible and that you answer their questions accurately. Step 3, after you've gotten the facts of the caller's situation, how did they enter the country, how long have they been in the country, you want to use those facts to give them information, resources, and referrals. You always want to point out to the caller that they should seek assistance from an immigration attorney or a BIA-recognized agency. And again, I'll point out to you in the manual where the resources for these agencies are. You see here our familiar question mark sign that we have at the events. This way, when you raise your question mark sign, this way you don't have to get up out of your seat or yell. We'll come on over and answer your questions. We want to point out all of the resources we have. We have some frequently asked questions that are also a part of the Getting Started guide that are really basic, common questions that people receive over and over again. So everybody should take a look at that and sort of familiarize yourself with the kinds of questions you'll be getting and the kind of information you want to provide. So at the end of the call, this is the stage where you want to make a good directed referral. And if you turn in your training manual to section 9B, there's a list of authorized immigration legal service providers. And you can see that as part of that list, each organization that's listed has information about where they're located and the kind of services that they provide. So for example, there's some offices that only provide services to people who are victims of domestic violence. You want to make sure that you give the person good, accurate information, maybe give them a couple of options, and refer to the manual because it's broken up by borough, and we have also some resources available from the New York Immigration Coalition for outside of the 5 boroughs. Sometimes people call from New Jersey, sometimes people call from Connecticut or Pennsylvania, sometimes people call from foreign countries. So we'll try to help them as well get information on the internet. This is just another reminder, please do not take the names or numbers of the callers. We really have a zero tolerance policy with this. It defeats the whole purpose of the call-in. We don't want to give people our name or our number, but you can provide referrals to your authorized immigration legal services office if you come from one of these many nonprofits. We have a whole list available, and I'm sure all of these offices are more than happy to help people. If people want the option of utilizing a private attorney, we have information available also for the City Bar Referral Panel and the AILA Lawyer Search Service. AILA is one of our partners, and a lot of the people who volunteer with us from AILA are specialists in particular areas, and this way you can match somebody up with the particular area of concern that they have. So there's a lot of topics that are in the manual that are not covered by the training that I just want to point out to everybody. There was a question for Midori during the AM session of the presentations about Freedom of Information Act requests. In Section 4 of the manual, there's a whole section on Freedom of Information Act requests. There's also a section on replacing and renewing documents. Section 6 is CUNY in-state tuition, and Section 7 is immigration, arrest, and detention. And you can refer to our archive training from 2011 on our website if you want more information at length about any of these trainings. We also have other webinars kind of laying out more detailed information than some of the training topics today. So you always want to kind of remember that when you're at home and maybe you're super bored and you want to do a little studying, you can look at the call-in 2011. So that is it for me. I'm always procedures girl. I'm going to turn it over back to Matilda. Thank you guys. It's great to see so many familiar faces, and we'll see you in a couple weeks. Thanks.
Thank you, Ms. Bloom. So before I introduce our next presenter, I just want to go over the reminders for folks in the audience again. If you have questions for the presenters during the Q&A session, please write them on the index cards and pass them to your left to staffers to collect. You will have a chance to ask questions about the entire training at the end of the presentations this afternoon. And for folks watching at home, you can send us your questions using the chat box on the right side of your screen. And all viewers here and at home can send their questions via our Facebook page or via Twitter using hashtag CNTraining. This session will actually be using the iClicker. So who has their iClickers ready? It has to be on. Show me your iClickers, everyone. Woohoo! It has to be on so that your answers can be counted. And after today's presentation, we will have people on either end collecting the iClickers. So let me introduce to you our next presenter. William Boyle is a staff attorney at the City College Immigration Center. He is a graduate of University College Dublin and was admitted as an attorney in New York in September 2006. Prior to joining CUNY, he worked for 2 years at the Emerald Isle Immigration Center in Woodlawn section of the Bronx. He is a member of the American Immigration Lawyers Association, as well as the New York County Lawyers Association, and he will be talking about naturalization eligibility and red flag issues. Please give a warm round of applause for Mr. Boyle.
Hello. Okay, so it's my job to kind of wake everybody up after lunch. Let me just point out to you before I start that we have this sheet in your packets, the orange sheet. So we decided to change the citizenship training a little bit this year to kind of more closely follow a screening sheet that you're going to have at the call-in, which is supposed to help you to ask callers relevant questions. Do you all have this? No? See, most of you have it. You'll have a copy of the call-in. This is basically a mock-up of what it's going to look like. So it basically asks you some basic questions to ask the callers, because most of the people who call are going to be asking questions of you, and they're going to be bombarding you with questions. I think it's important for you to be able to ask them certain important questions too. And the main questions that you should be able to ask them are, if they're asking whether they can become a U.S. citizen, you have to be able to ask them if they've been a resident for at least 5 years. Am I on the right slide? Yes. Have you been an LPR, lawful permanent resident, for at least the last 5 years? Did either of their parents become U.S. citizens before their 18th birthdays? Have they taken any trips outside the United States that lasted longer than 6 months? Have they ever had any interactions with any law enforcement agencies? Have they voted, failed to support their dependents, or failed to file a required IRS return? And can they speak, read, and write basic English and pass an examination on US history and government? So just from talking to them on the phone, you should be able to figure out the last one. Okay, so let me just break down a little bit these questions. Okay, so it's working. So a lawful permanent resident. Basically, a lawful permanent resident is somebody who has a green card. A green card gives somebody the right to live and work permanently in the US. It's not the same as non-immigrant visas, student visas like F1s, temporary worker visas like H-1Bs. LPRs are subject to certain limitations. They can be, and quite often are, deported. They can't take part in federal elections as voters or candidates, and they have limits on how much time they can spend abroad. So it's important to find out when somebody calls you up to find out if they actually have a green card. The fact that they've been living in the US undocumented or in another type of status for a long time is not the same thing. There's no squatters' rights when it comes to immigration. They have to be a lawful permanent resident. It means a green card of some sort. Okay, so we're going to go straight to a case study. So do you all have these? So when we were putting together the slideshow, we figured out that there was so much information on each page that we needed to have a second page, and we weren't able to put it up at the same time. So we put these in your packets so that you can read the substance of the question, and then I can move on to the actual question like that. So do you all have these? No? Anyone? Did you all skip the registration table on the way in? No? You're all in such a rush to get in for some Citizenship Now information? Okay. So Sebastian married a US citizen and applied for a green card in May 2000. He went to an interview with his wife in June of 2002 and received a stamp in his passport that said, approved for permanent residence. However, the card was mailed to the wrong address. When he applied to replace it in 2003, USCIS cashed the check and never mailed a new card. His employer never asked for proof of his status, and he hasn't traveled outside the US since his first entry in 1998. So he never followed up with USCIS. So he never actually received a physical green card. The question is, does Sebastian need to get an actual card before filing an N-400? A, yes, because he can't prove his status. B, no, because his wife is a US citizen. C, yes, because the stamp is not a green card. Or D, no, because the stamp is proof of LPR status. So if you all have your clickers, you can start voting now. What's up? It's good? So I'll give you, what, a minute to do this? Okay. Wow, you're all really fast. When they first suggested the clicker idea, I wanted to have the millionaire music playing in the background to make it more dramatic. Otherwise, I would just have to fill the silence, but, you know. There were some copyright issues, we couldn't do that. I think that's everyone, right? 126? 200? Are there 200 people in the room? All right, I'm going to give you to 60. It's so exciting, isn't it? Okay. So a lot of you voted for D. And you're right. D is the right answer. Well done. Go on, clap yourselves. Give yourselves a round of applause. Okay, so then the next question on our little screening sheet is about travel outside the US. So on the N400, there's an entire section devoted to travel because it's a very important area. And there's 3 separate issues that come into play here. One is continuous residence. Are you continuously residing in the US? The other is physical presence. And the third one is abandonment of your green card, or LPR status. So the first one, continuous residence. Basically, the Immigration Service wants to know if the US is your principal country of residence. Do you live here? In most cases, you have to continuously reside as an LPR for 5 years. You can apply 3 months before the 5 years, which means in essence that you're applying after 4 years and 9 months. If you've been married to and living with a US citizen, continuous residence is only required for 3 years. Again, you can apply 3 months before, but you have to have been married for a full 3 years at the time of the application, and the citizen has to have been a citizen for at least the 3 years, which is not usually a problem. There's other categories. If you got your green card as a battered spouse of a citizen, the 3-year period also applies to you, and there's no requirement that you be living with your spouse because you got your green card as a battered spouse. There's other rules for refugees, asylees, and the military. So if you're confused about any of this, please just raise your hand, ask an attorney, or somebody who's wearing a sash at the event, somebody who's walking around. Just feel free to ask questions, that's why we'll be there. Be aware as well that trips of 180 days or more in the 3 or 5 years can break the continuous residence, which means that somebody won't be eligible to apply until they have the full 3 or 5 years of residence, continuous residence. Okay, another poll question. So Isaiah became a resident through marriage to a US citizen on April 1st, 2008. He divorced on May 1st, 2010. When can he apply to become a US citizen? A is April 2011, B is April 2013, C is January 2013, or D is never. So I'm going to start the polling, and again, you have a minute. So again, the options are A, April 2011, B, April 2013, C, January 2013, D, never. Still a couple of you. What number did we get to the last time? 150? 45? I see a couple of people walked in late. Three, two, one. Okay, so 59 of you, which is 38%, voted for B. So the correct answer is actually January of 2013. The reason for that is he became a resident through marriage to a US citizen on April 1st, 2008. If he had stayed married to that US citizen, he would have been eligible to apply in January 2011. However, because he's divorced in 2010, he doesn't get that benefit anymore, which means he has to wait the regular amount of time. So he has to wait 4 years and 9 months from April 1st, 2008, which by my math is January 2013. Does everybody understand that? Okay, good. Okay, so travel abroad and physical presence. So as well as continuously residing in the US, the applicant must also be physically present for at least half of the 5 or 3 years. So that means you have to go through the passport as the applicant and count the number of days that you've actually been present in the US. Part of a day counts as a full day. So if you arrived at the airport at 11 o'clock at night, that still counts as a day in the US. Trips of a year or more can lead to a determination that the applicant abandoned his LPR status. Be careful, these are separate but overlapping or intertwined issues. Another poll question. I didn't realize I had so many poll questions so soon after each other. John has been an LPR since July 1st, 2007. He traveled to his home country, Sri Lanka. I don't know why I picked Sri Lanka. I just figured you could be from Sri Lanka and be named John. It's America. He traveled to his home country from March 1st, 2008 until October 1st, 2008. Since then, he has not taken any trips outside the United States. When can John apply for naturalization? So A, it depends on why he took such a long trip. B, April 1st, 2012. C, October 1st, 2013. D, depends on whether he is married to a US citizen. So I'm going to open the polling again. Again, you have a minute. So A, depends why he took such a long trip. April 1st, 2012, well, that would be 4 years and 9 months from 2007. October 1st, 2013, that's going to be, 5 years from October 1st, 2008. Or D, depends on whether he's married to a US citizen. Sri Lanka. I don't know why I picked Sri Lanka. It was like the most random country I could think of. I couldn't just say John from England. From where? Okay, only 133 this time? Oh. I really think that music from Millionaire would have just made it that much better. Next year? Okay, so we're pretty evenly split on this one. It's funny, when I ran this by the attorneys that work here, just before I came in this morning, they were also evenly split on this question, which made me wonder if I should even include it. So, to my mind, the answer would be B, April 1st, 2012. However, you could also make an argument that A is also the correct answer. Because he took a trip between March 1st and October 1st, so that's 7 months. A trip of 6 months breaks your residence. So if he took a trip of 7 months, the Immigration Service could make the argument that he broke his continuous residence, that he's not really living here, and they could deny him or attempt to deny his case for that reason. If John knows the law, if John is a lawyer, or he's somehow other well-informed, he might be able to make the argument to immigration that the trip didn't break his continuous residence. Maybe he was there for an unexpected reason, and that he kept a bank account in the US, he filed tax returns, kept an apartment, his job, and he always intended to return. It's basically an argument that he could make. It's a question that has two answers, really, which is probably why it shouldn't be in there. But the reason I put it in there is I wanted you to understand that when people call and you're asking them these questions and you're asking them how long they spent outside the country, it's important to find out if they've taken trips that are similar to this in duration. If it's 6 months, 7 months, 8 months, or even longer, it can be a serious problem. I mean, an application can be denied if somebody's broken their continuous residence or if they haven't been in the US, if they haven't spent enough time here, basically. And I'm definitely skipping that one. Because when I showed that to everybody this morning, everybody had a different answer for it. So I figured if we're going to hopefully teach you something here today, that wouldn't be a question to include. All right, so I'm going to go straight to the section on good moral character. So when you apply for naturalization, you have to demonstrate good moral character during the 3 and 5 year period and up to the time that they take the oath. Yes, people can get arrested at oath ceremonies, and yes, that actually did happen to a client of mine at my last job, luckily 2 days before I left the job. So I never actually found out what happened, but yes, he did go to the oath ceremony and got into a dispute with the officer about turning up late, ended up having a physical fight with the officer, getting arrested, being charged with disorderly conduct, and told he would not become a citizen that day. 2 days later, I changed jobs, thank God. So good moral character is not just about arrests and convictions. Voting in state, federal elections, not paying child support, even if not court-ordered, IRS issues, fraudulent receipt of public benefits, not registering for selective service. These are all issues that, while they're not criminal in nature, they can lead to a finding that a person does not have good moral character. And I think especially this year and possibly 4 years ago, voting is going to be a big issue because a lot of people who've lived here for a long time may think that they're citizens or presume that they're citizens because their parents are, and they may have voted. And it's a false claim to citizenship. It's not something you're supposed to do if you're not a US citizen. And it's a reason that an application for citizenship can be denied, and you can actually be put in removal proceedings for it. And it's something that happened a lot 4 years ago. A lot of people wanted to just sign up, vote for Obama, and vote. And a lot of them put themselves in the firing line for removal proceedings by doing that. And I'm sure there are quite a lot of people who are going to do that again this year. So you have to be aware of that. Child support, I mean, if somebody talks to you on the phone and they mention that they have children, they're not married, they're not living with, it's usually the father. I mean, it can also be mothers, but it's usually the father. They're not living with the mother. Maybe they make some sort of informal financial arrangements to support the child. That's fine, as long as they can document it in some way. If they go to an interview and it turns out that they have children who they just don't care about, they don't talk to, they don't see, they live with the mother and they have no contact, they don't support them in any way, that can lead to a finding that somebody is not a person of good moral character. Okay, criminal history. So certain criminal convictions and acts committed within the 3 or 5 year period, even without a conviction, can be temporary bars to citizenship and can lead to deportation proceedings. So this is a huge area every year. People call up and ask questions about incidents that happened in the 70s, 80s, 90s, crimes that may seem minor in nature, but can still be considered quite serious even today. So crimes involving moral turpitude, theft, fraud, forgery, assault, sex offenses, controlled substance offenses, all of these things are serious. So if somebody tells you on the phone that they had an incident a few years ago, it might seem minor, they think it was dismissed, they know it was taken care of, they're not more specific than that, that's a good opportunity to stop and ask someone, ask an attorney, ask somebody else in the room if you're not sure about how to proceed, because these things can be serious. People can get deported because of these, and they quite often do. So leading on from that, I mean, certain crimes are permanent bars to naturalization. So some crimes are so serious that no matter how much time passes between the time of the crime and the application, it's never going to happen. They're not going to make you a citizen. It's called a permanent bar. So the actual crimes themselves are called aggravated felonies, which is a term that immigration basically made up to cover serious crimes of this nature. So aggravated felonies doesn't always relate to what the state calls a felony or a misdemeanor. So even if the state calls something a misdemeanor, immigration may consider it an aggravated felony. So that's something that you have to research. You have to look it up and see what the latest case law is on that. So that's something that you definitely should not be afraid to raise your hand and ask somebody about. Parking tickets, disorderly conduct, fines don't usually bar you from becoming a citizen. They're not going to tell you that you're a person of bad character because you have a parking ticket. But on the other hand, if you have a pattern of repeat offenses, if you keep getting citations for minor offenses, that can look like you really don't care about the law, like you don't respect it. So that can lead to a finding that you don't have good moral character. And a case study. So James became a lawful permanent resident in 1980. In 1987, he was arrested for possession of cocaine and convicted in New York of possession of a controlled substance, 7th degree, which is a Class A misdemeanor. So New York State calls this crime a Class A misdemeanor. He paid a fine. He did not have to go to jail. Under current law, this is likely to be considered a controlled substance offense, but not an aggravated felony. So James doesn't have to worry about being permanently barred from becoming a citizen, but he does have to worry about the fact that it's a Class A misdemeanor. This is his only arrest. Can James apply for naturalization? So A is yes, he can apply because the offense was so long ago. B, no, because a controlled substance offense permanently bars citizenship. C is yes, he can apply if he's married to a U.S. citizen or has U.S. citizen children. Or D, yes, he can apply because a controlled substance conviction more than 5 years ago is not a permanent bar to naturalization. So let me go back again. LPR in 1980, 1987 he's arrested, convicted of possession of a controlled substance. It's a Class A misdemeanor. It's not an aggravated felony. He paid a fine, no jail time. It's his only arrest. It's a controlled substance offense, but not an aggravated felony. So I'm going to open the polling. Can he apply for naturalization? Wow, you're really fast this time. I'm impressed. So I know it's hard to kind of do the question if you don't have the actual poll questions. I can kind of flick back and forth between them, if that helps. So yes, because the offense was a long time ago. Well, it's a long time ago, no one cares. B, it's a drug offense, he can never become a citizen. C, he's married to a US citizen, he has kids, who cares? Or D, a controlled substance conviction more than 5 years ago doesn't bar him from becoming a citizen. So let's see, the moment of truth. D, right answer, very good. Oh, I'm so happy. I was scared that everybody would pick the wrong answer and it would be 100% the wrong color. Good for you. So then you all know that. You all know this. There's going to be no questions this year. Another one. Saoirse became an LPR on August 1st, 2007. That's a real name. It's an Irish name. It means freedom. I didn't make it up. He was arrested in New York in March 2009 after a fight with a coworker. It happens. And on May 15, 2009, he pled guilty to assault in the second degree. He wants to apply to naturalize as soon as possible because he wants to join the NYPD. Because that's just what the NYPD needs, is an Irish guy who likes to fight. Assuming that this is a crime involving moral turpitude, when may he apply to naturalize? Oh, I put that there already. So A, May 2012. B, May 2014. C, August 2014. D, never. Let me just read it once more. LPR in August 2007. Arrested May 15, 2009. So 2 years after he gets his green card, he gets arrested, a fight. Note it's not March 17th. He pled guilty to assault in the second degree. He wants to naturalize. So is it May 2012, May 2014, August 2014, or never? Oh, it looked like you started polling before I even pressed the button that time. Some good coffee. So May 2012 is A, which would be 5 years after he got his green card. B, May 2014, that's 5 years after the incident. August 2014 is 7 years after he got his green card. Or D, never. So 138 people, 139, 140. I feel like I'm doing an auction. And doing the weather at the same time. 144, is that the most that we have? 144? Okay. Closing the polling, 145. Split evenly again. So I see we're going to have some debate outside after this. So the right answer is May 2014. Give yourselves a pat on the back. Yeah. You're great. You did it. You're the only one. So why is it May 2014? So let's go back to the question. He became a resident in August 1st, 2007. So normally he could apply for naturalization, we'll say 5 years later, August 1st, 2012. He has this incident in May 2009. That's within the last 5 years. So now he's basically stopped the clock for naturalization. He has to wait for 5 years from the date of this incident. So basically 5 years from this is May 2014. So it's answer B. You all got that right, even though you pressed the wrong button. So continuing on with good moral character. Texas Selective Service So with the taxes is a big thing. I mean, people presume that no matter what else you do, you could be a serial killer, have bodies stored in your basement, but you file taxes, it's okay. That's not actually true. I mean, the USCIS expects you to file a tax return, but only if the IRS does. So if you're working, generally you're required to file a tax return. If you're 85 years old, you got your green card 5 years ago, you've never worked in the US, you live with your son or daughter who sponsored you, they're not going to ask you to go out and file tax returns. The IRS doesn't expect you to do it, so neither does the Immigration Service. Selective service. So any males who are between the ages of 18 and 26 and live in the US in any status except for non-immigrant visas. So basically, men who are in the US except F1s, J1s, H1Bs who are non-immigrant visas, all men between the ages of 18 and 26 are supposed to register for selective service. It's basically a list of names that the government keeps in case they want to reinstate the draft, which they haven't done since the 70s. And they see it as a sign of bad character. If you don't sign up on that list, it shows that you're not willing to defend the United States from its enemies, which is part of the oath that you're supposed to take when you become a US citizen. Deadbeat dads and moms. So as I mentioned before, if you don't pay child support, that's a sign of bad character. You can be denied for that. So if there's no court order in place in that kind of situation, if somebody can show an informal arrangement that they pay the mother by check, by money order, in a regular fashion, then they can get around that particular ground. Unlawful voting after 1996. As I said before, voting for Obama is not an excuse. And another big one, English language and US history and civics. So most applicants have to show that they can speak, read, and write basic English. There are certain exceptions to that. If you are 55 and have had your green card for 15 years, then you can take the US history and civics exam in your native language. The same applies if you're 50 years or older and you've had your green card for 20 years. So what this 55, 15, and 50, 20 rule, it causes a lot of confusion. It's not an exemption from the entire exam. What it means is that you can take the test in your native language. It doesn't exempt you from the test. You still have to take the test. It's just that you get the advantage of taking it in your own language. If you're 65 and you have 20 years of permanent residence, you get an even shorter list. It's still a test, but it's in your own language and it's shorter, but it's still a test. The only way to exempt yourself from the test entirely is to have a doctor agree that you have a disability of some sort, usually a neurological or psychological or psychiatric malady that prevents you from learning. So that's quite a difficult thing to do. I mean, it's not the fact that you are old and you don't want to learn or you don't want to take classes and you think it shouldn't apply to you and that you don't want to do it. That's not a disability. It's not an exemption. A disability is somebody who's got a brain injury, something that prevents them taking in new information, learning, speaking, all those kinds of things. So a disability waiver is something that a doctor has to sign off on. And it's on a special form called an N648 that somebody has to submit with their application. And it's, CIS will challenge that quite often. They're not going to just accept the doctor's word that, she has memory problems, she can't learn English. They want a detailed explanation of what the condition is and why it prevents somebody from learning. So that is the only way that you can be exempted from the exam entirely. And that's it. So because I skipped one of my questions, I'm done a little bit earlier than I thought. So I'm going to turn it back over to Matilda. Thank you.